Okay, awesome. I'm Allison Harrison, and I'm here with litigation attorney Shelby Nathans. We're going to talk through what litigation is, what it isn't, and what to do when you get that doggone summons. That's usually how it happens. We tend to be on the defense side on these cases, and so when our clients come to us, they've gotten something in the mail and they don't really know what it is. So, what starts a lawsuit, Shelby?
Well, the first thing that starts a lawsuit is a summons, like Allison mentioned. So you will get a summons in the mail, and usually that comes along with a complaint. The complaint says, hey, you're being sued in Ohio. You have 28 days to respond to that lawsuit. And then that's usually when someone ends up on the other end of the line for me.
Okay, and does a complaint? Ohio's a notice pleading state, so the complaint says some things, but it's not like super detailed, right? Like it gives enough information.
A complaint, what notice pleading means is it's basically the complaint says enough to put you on notice of what you're being sued for, but it doesn't go into great detail. So it might say, hey, you're being sued for breach of contract, or consumers filed a complaint against you for, selling a vehicle, but it's not going to say necessarily the who, what, where, when, and why. It's definitely not going to say the how.
Does it always say the dollar amount you're being sued for too?
No, it usually lists sort of a ballpark amount. So it'll say in excess of $25,000 or in excess of $75,000. It depends on the court. And then later, as the lawsuit progresses, damages get proven.
Okay, all right. So we get the complaint. We've got 28 days in Ohio to respond. What does a response look like?
So a response either consists of an answer where we go line by line through the lawsuit and answer each of the allegations saying, we deny this, we deny that, we admit this, we admit that, or we will file a motion to dismiss or another kind of motion depending on whether the plaintiff filed in the wrong court or the wrong state, or if there's some procedural defects with the complaint that we can try to use to get it thrown out before the lawsuit progresses.
And sometimes we have what? A motion for more definite statement that says, even in the notice pleading state, I don't know what you think we did wrong, right?
Right. So sometimes, the complaint is just too bare bones, as we like to say, or too vague. And then we will file for a motion for a more definite statement. And that puts the ball back in the plaintiff's court to say, hey, we hear you're suing us, but we don't understand why. And you have the burden to give us a little bit more information to go on.